Hello, my name is Kevin Connor. Let me begin this video by informing you of my living situation. I live in a house owned by 4 beautiful kitties, and as a result, these kitties love to grab my attention in the middle of a video or when I'm writing a report. Therefore, I have created a script of my best attempts. As a result, you may see a jump cut, or you may see me do this as I double check where I am in the script. These are things that I believe need to be said. Let's get on with it. Hello, my name is Kevin Connor, and I own and operate Ninja Nezumi Productions, LLC, a limited liability company began for the sole purpose of me conducting my business and sales through platforms such as Amazon or eBay. I am also president, CEO, whatever you may call it, of GEB, a 501c3 recognized by both the state of Colorado and the federal government. I am also the inventor of Tora, a classical-style board game, otherwise often described as abstract strategy, in the same vein as chess or Chinese chess, but obviously not chess or Chinese chess. I'm making this video to make a public statement. In addition to copyright protection, Tora is patented in both the United States and Australia. Unfortunately, I need to make a statement about the attempts to patent protect it in Canada. My statements about expecting it to be patent protected in Canada, including all statements about its patent pending status, were made based upon the false and misleading statements of my patent attorney, Kurt Leyendecker of Leyendecker and Lemire. Peter Lemire being his partner, Leyendecker and Lemire operating out of the greater Denver metro area in Colorado. Kurt Leyendecker fed me several false statements and withheld critical information, which resulted in me being told and directly led to believe that the patent in Canada was going to happen. That Canada accepted method patents. Canada has never accepted method patents at all. In fact, back in the late 1990s, the possibility of Canada accepting method patents was settled in court. Numerous challenges have been made since the late 1990s decision, and all of them have been struck down. That's because the law in Canada governing patents does not accept or recognize method patents by the furthest stretch of the imagination. When this was brought to Kurt Leyendecker of Leyendecker and Lemire, Kurt Leyendecker said, paraphrased, "Oh, wait, it's not a method patent. This game's like Mousetrap. It's your arms and mechanics of your body using to move pieces across the board." Paraphrased again. It was a long discussion. There's no argument for that Mousetrap concept, at least none that I can find, either in the filings or even a mechanical patent application for any other physical game. And if there were, I see no physical distinction of using one's arm to move a game board piece being any kind of unique invention. Humans have been using their limbs to move objects and game pieces of whatever they're playing since humanity existed. If anything, I would imagine some sort of God or evolution would have held the rights to this long expired patent concept. In addition to that, the Tora board game is an abstract strategy board game. Very clearly an abstract strategy board game. Something that Kurt Leyendecker claimed to the ARC, that's not true. It's never been an abstract strategy game. Only lightly paraphrased. He even denied comparisons with chess to the ARC, despite the fact that chess and other abstract strategy games are comparative references within the patent application. This leads me to believe that he doesn't know the definition of abstract strategy, or he never played or read the rules to my board game, despite the fact he was gifted 2 sets. And 1 set was presented at their annual client party. The bulk of all the patent applications came from the first, which was written by me. Not being an attorney, I left out the crucial step of legal citations, the legal verbiage of the kind of application I was applying for, which amounted to a few sentences of writing, important sentences, but just a few when compared to the bulk of the work, sentences added by Kurt Leyendecker of Leyendecker and Lemire. Oh, and numbering. He added the numbering. He was very good at numbering my claims. A crucial sentence in all the applications focused on the claim it was a method patent. The key sentence in the Canadian application, number 2570230, was numbered 1 on the claims list. A method of playing a game. The method comprising, : When we reported him to the ARC, that's when we discovered he had initially had a conversation with a member of Sim and McBurney, the Canadian patent law firm through which he had to go in order to apply for my patent. At the time, this individual said, paraphrased, only lightly, "Oh yeah, method patents aren't allowed in Canada. But I don't think the ruling is solid, so we can probably fight it on appeals." So, Leyendecker and this individual from Sim and McBurney, apparently this individual who never communicated with upper management. I found that out later. Decided in their own strategic planning that they were going to push it to appeals. Such an appeal would have easily cost $250,000 to $500,000. None of this information was given to me at the time that it was pertinent. Not until after Kurt responded to our complaint with the ARC. When I notified the ARC, we did not receive this information until Kurt responded to our complaint. The ARC responded in their infinite wisdom that an attorney is not required to notify their client of any information involved in their strategic decision-making process. So I had to make a decision as a client about pursuing a patent in Canada without having any of the critical information required to make such an important decision. I did not know about their plan to charge me hundreds of thousands of dollars to pursue an appeals decision designed to change a law in Canada, let alone about the Canadian rulings and laws written that restricted such a patent from ever being successful or recognized in Canada. There are other things I have to complain about regarding the behavior of Kurt Leyendecker of Leyendecker and Lemire. Things that I sent to the ARC, things that the ARC never addressed. So, attorneys in Colorado are allowed to give false information to their clients. Such false statements as, method patents are allowed in Canada, even after they are told that they're not. It's legally allowed for attorneys in Colorado to give false and misleading statements to the ARC, such as Kurt Leyendecker saying, "We never applied for a method patent," despite the fact we have audio recordings and emails from him expressly stating that he applied for a method patent, and the opening line of the Canadian patent application claims, 1, a method of playing a game, a method comprising, : If I were to do this to one of my clients with my business, I know I would be hauled in on fraud charges, or I would lose my business license, or both. So as you can expect, I wholly reject the ARC's competency and finding and investigation in this matter. I could probably have sued Kurt had I had the money and family issues hadn't arisen, which required immediate attention. But we'll never know. However, I will say that under no circumstances did I ever intentionally attempt to mislead anybody. I place the full responsibility on Kurt Leyendecker of Leyendecker and Lemire, who concealed information from me, gave me false statements, and proceeded to conduct himself in a way where I was not capable of making an informed decision on the direction of the patent or statements to the public. All of that I consider to be Kurt's responsibility. I don't know if he did this in a way where he was aware of his actions, or if he truly had no concept of my case or my patent. That's a question left up for the ages. All I know is that on the audio recordings illegally done in Colorado, and in attorney-client communication, he routinely contradicted himself, routinely stated the opposite of the files and information of the files, and information in which he was in possession. And I have no idea how or why the ARC believes it's perfectly okay for attorneys to behave in such a fashion. Having said that, your mileage may vary with Kurt Leyendecker of Leyendecker and Lemire. All I know is that I have all of the information for you in a couple of Google Drives, and I'm going to link them below this video. I'm allowed to disseminate this information as I see fit, since this is my property and not his. The protection is for me and me alone to decide. So I am releasing this information for the public at large to review. I would also like to point out the names and members of the ARC who did not conduct a full investigation, who refused to respond to several issues we had, who claimed that the evidence we provided was not real evidence or somehow verified because we provided it, as opposed to the court or an attorney providing it, something which is not a law in the state of Colorado. Individuals are absolutely allowed to provide evidence, and it is to be taken as evidence, not as someone's opinion, as put by the ARC, or spectral evidence, as is the correct term. So I fully reject the ARC's competency, and I will say that as many times as I need to. And I will point out the names of the attorneys who operated out of that division of the ARC, and I would love for you to review who was involved in all of this. Thank you, and have a wonderful day.